Hello, everyone. Welcome to Unit 7. This is contracts. And be on the lookout in our brain food folders. I will be putting some extra videos that are specifically going over the main contracts that we have in real estate. And those are to just for your own education. So, our learning objectives on this unit, we're going to be able to define excludatory, executed, express, implied, bilateral, and unilateral contracts. Explain the elements of a valid contract and how a contract becomes void, voidable, or unenforceable. Describe the effect of a counteroffer or a rejection of an offer. Explain how an offer can be revoked. Identify the provisions of the statute of frauds and the statute of limitations. List the ways in which a contract can be discharged. And finally, define an option and exchange. All right, let's get right into it. And here is the full list of your key terms. We'll leave the key terms up for just a while so that you have time to take a look at what we're going to be talking about.
What is a contract? A contract is a promise made by one person to another to do something or to refrain from doing something. A person who takes part in a contract is referred to as a party to the contract. The contract promise may be made by only one of the parties, or a separate promise may be made by each of the parties. The promise each party makes is called that party's contractual obligation. An offer to perform a contractual obligation is called a tender. A contract must meet certain requirements to be legally valid. If the contract is valid, each party has the duty to perform their specified contractual obligations. A party who does not fulfill the promise made, who defaults in completing the contract terms, will be liable to the other party for breach of contract. A real estate listing agreement and a real estate purchase contract are examples of the most common types of contracts used by real estate agents. Let's examine a typical form of real estate purchase contract. We begin with definitions of some of the terms we will use throughout this unit. They include the following: executory and executed contracts. A contract is said to be an executory contract when some future contract obligation is yet to be performed. A listing agreement is executory because the real estate broker must find a buyer for the listed property to earn the compensation promised by the seller. Until the sale is closed, a real estate purchase contract also is executory. The buyer must find financing for the purchase, and other conditions must be met before title is transferred. When all of the contract obligations have been performed, the transaction is completed and the contract becomes an executed contract. Note, don't be confused by use of the word execute to mean contract performance, as well as the signing of a document. For example, after the terms of a property listing agreement have been decided on and prepared in written form, both seller and broker execute consent to the agreement by signing it. Then the parties fulfill the agreement by performing all of its obligations. Express and implied contracts. An express contract is established by an oral or written agreement in which the parties declare their intention to make a contract. An implied contract is established by the conduct of the parties without a specific oral or written agreement. Bilateral and unilateral contracts. In a bilateral contract, both parties make a promise to do something or to refrain from doing something, and both are obligated to perform. In a unilateral contract, only one party promises, and only that party is obligated to perform. The promise is accepted by the performance of the other party. Valid, void, voidable, and unenforceable contracts. A valid contract can be created easily if all of the required elements are present. The parties must have the legal capacity to enter into a contract. There must be an offer by one party and acceptance of that offer by the other party. There must be a lawful object to the contract. There must be some form of consideration or payment supporting the contract. The contract may have to be written. Each of these elements is discussed in the next section, Elements of a Contract. A void contract is one that has no legal effect from its inception. An agreement to do something that is illegal is void. Elements of a contract. Legal capacity to contract. All parties must have the legal capacity to contract. This means that they must have the legal ability to make a contract. If they do not, either the contract will be voidable by the person who lacks the capacity to contract, or the contract will be void from its inception. A minor in California, anyone younger than 18 generally cannot make a contract concerning real estate. Any such contract is void. Contracts for necessaries items needed for the support of the minor or the minor's family when the minor is not under the care of a parent or guardian cannot be disaffirmed, cancelled. A minor can contract as an adult for all purposes as an emancipated minor. A minor becomes emancipated by marrying, joining the armed forces, or petitioning the court, which may approve the petition. Contracts in languages other than English. Many California real estate transactions involve parties for whom a language other than English is their first language, in some cases the only language. As a result, contracts are frequently negotiated in a language other than English. Civil Code Section 1632 imposes special requirements on any person engaged in a trade or business, such as a real estate licensee who negotiates orally or in writing primarily in Spanish, Chinese, Vietnamese, or Korean in the course of entering into any of a variety of agreements or required disclosures, including the following: lease, sublease, or rental agreement for a period of longer than 1 month of a dwelling, apartment, mobile home, or other dwelling unit normally occupied as a residence. Loan negotiated by a real estate broker and secured by a lien on a dwelling of 1 to 4 units. The law applies to the loan disclosure statement made by the broker. Reverse mortgage. Contracts in languages other than English. Before the English language version of the contract is signed, the party to the contract must be given an unexecuted translation of the contract. A translation in the applicable language also is required for disclosures made by financial organizations under the Financial Code or the Federal Truth in Lending Act. The law does not apply if the party to the contract uses his own interpreter. The interpreter cannot be a minor, must be able to speak fluently and read with full understanding both the English language and the specified language in which the contract or agreement was negotiated, and cannot be employed by or made available through the trade or business. Any minor may receive property as a gift or an inheritance, usually taking title without the appointment of an adult guardian. A guardian must be appointed, however, to handle any property conveyance, lease, encumbrance, or other transaction on behalf of an unemancipated minor. If someone makes a contract while drugged or intoxicated, the contract is voidable by that person. The person who is impaired can decide later to let the contract stand or can disaffirm it. A mentally incompetent person cannot form a valid contract. Any such contract would be void. A person may be determined by a court to be mentally incompetent. Even without a judicial determination, however, evidence may show that a person is without understanding and thus unable to form a contract. The property of a deceased person is handled by the personal representative of the estate. This can be either an executor named in the deceased's will or an administrator appointed by the court. If no executor was named by the deceased, or if the named representative declined to serve, actions of the estate representative must always be approved by the probate court. Contracts by businesses. A business entity can make a contract concerning real estate. A sole proprietor acts in their own name, or with a spouse. A partnership may hold real property in the name of the partnership, the name of one of the partners, or the name of a trustee. Any authorized partner and spouse may contract to transfer the real estate. A corporation acts through its officers as authorized by the board of directors. The directors may be personally liable for actions taken on behalf of the corporation. When dealing with a business entity, it is important that the authority of the person acting on behalf of the business be verified and documented. Mutual consent. A contract is not created until the parties show that they have given their mutual consent to its terms. There must be some form of a meeting of the minds to create a valid and enforceable contract. This normally takes place in a process called offer and acceptance. An offer by one party is accepted by the other party, and the acceptance is communicated to the person making the offer. An offer exists only when the offer of the person making the offer has communicated its terms to the offeree, the person receiving the offer. The fact that an offer is being made should be clear. Because a standard, well-detailed form is used in most real estate transactions, establishing the intent of the offer usually is not a problem. Rejection. The offeree can refuse to accept the offer. Rejection of an offer can be accomplished by simply taking no action that would indicate acceptance and allowing the offer to expire. An offer is also rejected if the offeree makes a change in its terms as a condition of acceptance, resulting in a counteroffer to the offerer. Then their roles are reversed. The person making the counteroffer becomes the offerer, and the person to whom the counteroffer is made becomes the offeree. Counteroffer. A counteroffer is created by any change in the terms of an offer as originally made. There may be considerable negotiation required to finalize a contract. At each step, an offer by one side may be met by a counteroffer from the other side. Any counteroffer has the effect of rejecting the offer that it counters. The previous offer on the terms proposed is terminated. It can no longer be accepted by the party to whom it was made. This means that if a counteroffer is rejected, there is no longer an offer that can be accepted by either party because both the original offer and counteroffer have terminated. The asking price for a Tahoe residence is $995,000. A couple offers $920,000 for the house. The seller makes a counteroffer of $950,000. The counteroffer is rejected, and the seller decides $920,000 is not such a bad offer after all, and signs the original purchase contract, returning it to the couple. Can the seller do that? No. Once the seller made a counteroffer, the seller effectively turned down the couple's original offer. Of course, the couple is free to ignore that point and simply go ahead with the transaction. Revocation of an offer. In general, an offer may be revoked before it is accepted if the offeror communicates the revocation directly to the offeree. It also is revoked if the offeree learns of the revocation from a reliable source, such as the real estate agent, and observes the offeror do something that is not consistent with the offer still being considered. Example: an engineer for a local software company fills out a rental application at Ocean Villas and is told to expect a response in 2 days. The next day, the engineer learns that the software company is moving its office to Modesto. News of the move appears in the newspaper the same morning, and the manager at Ocean Villas sees the article. The manager phones the company and learns that all employees will be relocating to Modesto. Before the engineer can get back to Ocean Villas to withdraw the rental application, the manager signs it and faxes a copy of the rental agreement to the engineer. Does the manager have a new tenant? No. Once the manager learned of the prospective tenant's change of circumstance from a reliable source and verified it with a phone call to the applicant's place of business, the manager had sufficient notice of the intended revocation of the application. The exception to the revocation rule: an offer is revocable before acceptance unless it is supported by some form of consideration payment. An example is an option agreement entered into by a prospective purchaser and seller. The prospective purchaser gives the seller some consideration for the option, usually money. In return, the purchaser receives the right to purchase the property during the option period. During that time, the seller is not allowed to revoke the buyer's right to exercise the option and is not allowed to sell the property to anyone else. Offer made freely and voluntarily. For a valid acceptance, the offeree must not be acting under threat of harm, undue influence, mistake, or as a result of a fraudulent misrepresentation by the offerer. A contract is voidable if it is entered into under threat of harm to a person or thing. No undue influence or fraud. Undue influence may not be used to gain an acceptance. Most often, this happens when the parties are related or known to each other, and one of them takes advantage of that position of confidence. No undue influence or fraud. A fraudulent act is either affirmative or negative. Fraud is affirmative fraud when it is a deliberate statement of a material fact that the speaker knows to be false and on which the speaker intends another person to rely, to that person's detriment. Fraud is negative fraud when it is a deliberate concealment of something that should be revealed. Actual fraud can be any of the following actions, as long as it is performed with the intent to deceive: the suggestion as a fact of that which is not true by one who knows it is not true; the positive assertion, in a manner not warranted by the information of the person making it, of that which is not true, though the person believes it to be true, that is, the belief is not justified; the suppression of that which is true by one who knows of or believes the fact; a promise made without any intention of performing it; any other act of deception. Constructive fraud is a misrepresentation made without fraudulent intent, that is, deliberate intent to deceive. An agent can reasonably rely on some information, such as the owner's report of the results of a termite inspection, though it would be better practice to ask for a copy of all pertinent reports. Other information, however, such as the construction of a new school, should be verified. The agent could be guilty of constructive fraud if the information turns out to be false. Penalties for fraud. A contract induced by fraud is voidable by the injured party. Action must be taken within a reasonable time after the fraud is discovered, as specified by the statute of limitations. The injured party may also seek money damages, including punitive damages. A criminal prosecution may be brought against the person who committed the fraud, resulting in a fine, imprisonment, or both. A real estate agent who takes part in fraud may suffer loss or suspension of the real estate license, in addition to the penalties mentioned above. And note that a fraudulent misrepresentation is different from a negligent misrepresentation. A negligent misrepresentation is not made with criminal intent to deceive. It is the result of carelessness. Although negligent misrepresentation carries no criminal penalties, it can result in a voidable contract, civil damages, and disciplinary action against the licensee. Definite terms. The subject matter of the contract must be clearly expressed in definite terms. If the subject matter is real estate, there must be an adequate description of the property. All parties must be identified unambiguously. The full name and address of each are preferred. The price must be specified in a real estate contract, unlike contracts for other types of property in which a reasonable market price may be inferred. It would be sufficient in a real estate contract to state the manner in which the price is to be determined, such as the opinion of market value of an identified licensed appraiser as of a specified date. The terms that specify the nature of the transaction and any conditions to its performance must be clear. The time of performance is important, particularly in real estate purchase contracts. Deadlines for certain activities, such as qualifying for and obtaining a loan, should be given. Example: offers to purchase the P residence. The offer describes the property as the P residence on Gray Street, Meadowville, Yolo County. Is this description adequate? Is it advisable? The description could be adequate if P owns only one house on Gray Street. It is not advisable, however. Not only could P own more than one house on Gray Street, there is no description of the land involved. A lawful object. One cannot make a valid contract to perform an illegal activity. An example is an agreement to use real estate for an unlawful purpose, such as the manufacture of illegal drugs. If the contract has a lawful as well as an unlawful objective, it will be valid only to the extent that the lawful object alone can be carried out. Consideration. A contract must be supported by consideration, an obligation, or a payment on the part of each party to be enforceable. The fact that each party supplies consideration is referred to as mutuality of contract. The consideration can be a promise to do something or refrain from doing something in the future. As noted earlier, if consideration has been given to create a valid option, the option agreement cannot be revoked by the person giving the option before the end of the option period. Example: H gives C a 1-year lease and an option to buy a house in exchange for $5,000 in monthly lease payments of $3,000. Before the year is up, H decides to give the house to a relative. H notifies C by certified mail, enclosing a money order for $5,000. Does C still have an option to buy the house? What can C do? C still has a valid option contract, but will have to return the $5,000 to H. If C delays, C may be understood as approving revocation of the agreement. If C had already decided or decides when the $5,000 arrives not to exercise the option, C is $5,000 richer than if H had not returned the money. Either way, C should talk to an attorney. Or writing. Certain agreements are enforceable only if they are in writing. A handshake deal may work perfectly well as long as the parties have no problems, but if something goes wrong and one party backs out, the other party won't be able to enforce the agreement. The statute of frauds. The statute of frauds is a part of the California Civil Code that originated in the English common law. The statute of frauds lists the types of contract that must be in writing. They include the following: an agreement that will not be completed within a year. an agreement for the sale of real property or an interest in real property or the lease of real property for more than 1 year, and an agent making such an agreement on behalf of a principal must be authorized to do so by a written agreement. An agreement that employs an agent, a broker, or any other person to purchase or sell real property, lease real property for a period longer than 1 year, or find a purchaser or seller of real property, or a lessee or lessor of real property where the lease period is for longer than 1 year. An agreement by a purchaser of real property to pay a debt secured by a mortgage or deed of trust on the property purchased, unless the purchaser is to assume the debt. Discharging a contract. A discharge contract is one that is terminated. As discussed next, there are many ways to terminate a contract or change one or more of its terms, including the following: performance, rescission, release, novation, reformation, assignment, breach. Performance of its terms discharges a contract. A contract may be discharged if some intervening cause creates an impossibility of performance, such as when the property that is the subject matter of the contract is destroyed. If a buyer of real estate suffers an unexpected disability and job loss, making it impossible to go through with the purchase, the buyer's performance will be excused. Performance may be excused in the event of impracticability of performance, also called commercial frustration. If changed circumstances make a purchase uneconomic, there may be an excuse for non-performance. This might be the case if a buyer's financial condition were to take a downturn, say, a sudden, extreme drop in market value of the buyer's company's stock, so that the purchase, although not impossible, would impose an extreme financial hardship. There also could be other reasons that were not known at the time the contract was formed. Rescission. If both parties agree, they may take back, rescind the contract in the process called rescission. Release. A party to whom an obligation is owed may sign a written release, possibly for further consideration. The contract is then discharged, and the other party no longer has an obligation to perform. Novation. By a novation, the parties may substitute a new agreement for the original one, discharging the original agreement. If the new agreement falls within the statute of frauds, it must be written. P and Q, a married couple, make an offer to purchase the Castle estate. The offer is accepted, and the closing of the sale is to take place in 2 months. Before the closing date, P and Q decide to dissolve their marriage and live apart. A loan. Neither can qualify for a loan to purchase the Castle estate. What can P and Q do to get out of their offer of purchase? P and Q should immediately inform the Castles, who may agree to rescind the contract. If not, P and Q could refuse to perform on the grounds of impracticability, but should consult an attorney first. Reformation. At some point during the life of the contract, one of the parties may determine that a mistake has been made in the contract terms, or that certain information should be made a part of the contract. There may be an inaccurate description of the subject property, the financing terms may need to be clarified, or new information may be discovered about the true condition of the property, particularly following an appraisal or property inspection. In any of those instances, it may be possible to bring about a reformation of the contract. If all parties agree to the reformation, it is simply a matter of redrafting the contract or amending the escrow instructions. If one party objects, it is possible to bring a legal action to reform a contract, although the time and expense of a legal action usually make this alternative undesirable. Assignment. Unless the contract requires a personal service or specifically prohibits an assignment, it probably can be assigned. In an assignment, the assignee is the new party who takes on the duties of the assigner, the party who makes the assignment. In return, the assignee receives the compensation that would have gone to the assigner. Breach. A contract also may be discharged by a breach of contract. A breach occurs when one of the parties fails to perform all or part of the obligations required by the contract. Then, on breaching party who is injured by the breach is entitled to legal relief. An injury due to breach of contract entitles the injured party to ask for money damages. With some forms of contracts, specific performance of the contract also may be sought. If a court grants specific performance, the breaching party must fulfill the terms of the contract. Specific performance will be ordered only if the subject of the contract is considered unique and not readily replaceable. By definition, no parcel of real estate is exactly like any other parcel of real estate. A court will not order specific performance unless the contract is supported by adequate consideration. This requires an offer tender of the entire purchase price by the offerer. Specific performance also will not be granted if the contract involves a personal service of the breaching party or if the agreement involves securing the consent or conduct of a third party. No two parcels of real estate are exactly alike. Specific performance can only be obtained by bringing a lawsuit, which is expensive and time-consuming. As a result, this remedy is not sought very often. Most buyers of residential real estate have neither the ability nor the inclination to litigate a claim to a particular parcel of real estate. The injured party in the breach of a real estate contract can ask for either money damages or specific performance. In some cases, both may be sought. Damages may include the return of any consideration already given to the breaching party if specific performance is not being sought and payment of any expenses incurred because of the breach. Example: a week before closing, P&Q, who have reconciled their differences, decide against buying the Castle estate. What recourse do the Castles have when informed of this decision? The Castles can agree to rescind the contract and either keep or return the earnest money deposit. If the Castles keep the deposit, P&Q could sue for its return. The Castles could agree to release P&Q from their contractual obligation but retain the security deposit as consideration for the release. Or the Castles could sue P&Q for specific performance. Most likely, the Castles will sell the property as soon as possible to someone else and sue P&Q for any loss in value that might result. The injured party also could decide to waive the matter breached and enforce the contract on its remaining terms. Another use of a waiver is to remove a condition that a party has the right to enforce. Y offers to buy the Z residence contingent on Y selling his current home within the next 30 days. Z receives another offer that has no contingencies. Z asks Y to remove the home sale contingency from their offer to purchase within 48 hours, as is permitted by the contract. Y decides to go forward with the purchase, even though Y has not yet sold the old home. To do so, Y signs a waiver of the home sale contingency in the contract with Z. Often, the facts of a case may support more than one remedy. In any situation potentially involving a lawsuit, the advice of a real estate attorney should be sought as early as possible to ensure that no legal rights are lost. Statute of limitations. A legal action lawsuit must be brought within a specific period after the act that gives rise to it. The statute of limitations prescribes time limits for various lawsuits. You can remember the deadlines below by remembering the numbers 543210. A lawsuit to recover title to real property must be brought within 5 years. An action based on a written instrument such as a real estate sales contract must be brought within 4 years. An action based on fraud must be brought within 3 years of the discovery of the fraud. An action based on an oral agreement such as a lease for only a few months must be brought within 2 years. An action based on a judgment must be brought within 10 years of the awarding of the judgment. Statute of limitations. A legal action lawsuit must be brought within a specific period after the act that gives rise to it. The statute of limitations prescribes time limits for various lawsuits. You can remember the deadlines below by remembering the numbers 543210. A lawsuit to recover title to real property must be brought within 5 years. An action based on a written instrument such as a real estate sales contract must be brought within 4 years. An action based on fraud must be brought within 3 years of the discovery of the fraud. An action based on an oral agreement such as a lease for only a few months must be brought within 2 years. An action based on a judgment must be brought within 10 years of the awarding of the judgment. Real estate contracts. The two parties to a real estate purchase contract are the seller and the buyer. Real estate purchase contracts. When someone is ready to make a purchase offer, the next step is the preparation of a purchase contract. The offer to purchase usually includes a deposit on the purchase price, so the purchase contract will also serve to acknowledge receipt of the deposit, if the offer is accepted. As with any contract, a real estate purchase contract must be made by parties who have the legal capacity to do so. There must be an offer made on definite terms and with a lawful objective. There must be acceptance of those terms by all parties, and the contract must be supported by some form of payment or consideration. Use of a printed form. Remember, until the purchase contract is signed by the seller. It is an offer only and can be withdrawn by the buyer at any time before acceptance. Because such a contract is long and quite detailed, it is likely to contain corrections and written additions. The general rule regarding pre-printed forms is as follows. Typed insertions take precedence over pre-printed material. Handwritten insertions take precedence over both typed and pre-printed material. Specific information takes precedence over general information. Duties of the broker. A real estate broker or associate licensee may guide the buyer through the contract provisions and fill in the required information. Then the broker will present the offer to the seller in the presence of the listing broker, if that is a different person from the selling broker. The broker who prepares the contract is not allowed to give legal advice but can explain the meaning and purpose of the contract terms to the buyer and seller. The listing broker, if there is one, has primary responsibility for dealing with the seller. If there is a different selling broker, the listing broker most often will discuss the contract terms privately with the seller after the offer has been presented by the selling broker. Contract terms. The residential purchase agreement and joint escrow instructions first requires insertion of the date on which the buyer is signing the offer. The numbered paragraphs refer to the numbered sections of the contract offer. The buyer's full name is entered. The city and county in which the property is located are provided, followed by a legal description of the property. A street address may be sufficient for city property, but a formal legal description meets and bounds or lot and block could be used in addition and is required for rural property. The exact acreage need not be specified, but if it is and a survey reveals a significant discrepancy, for instance, 165 acres surveyed when 185 acres are specified in the contract, a problem may arise later. If a lengthy legal description is needed, it is better to make a photocopy of the description from a reliable document and attach that to the contract, rather than risk an error in transcribing. Agency. All agency relationships between the parties and broker involved in the transaction are confirmed. Finance and other terms. This section has been expanded to provide a summary of all of the important financial elements of the transaction, from the purchase price and down payment to the details of the buyer's loan, any contingencies to fulfillment of the contract, when the buyer will take possession, which items will be included in the sale, and how a variety of costs will be allocated. By summarizing all of this information at the beginning of the form, the transaction costs and deadlines are easy to find. Addenda and advisories. Specific disclosures to be made by the seller are identified. The buyer's inspection is so important, it is the subject of a separate buyer's inspection advisory form that may be included. Additional terms affecting purchase price. Disposition of the deposit and any special loan terms are included here. Additional financing terms. The buyer verifies loan approval. Closing and possession. Will the buyer live in the residence? Buyers should understand that this is an important question for a number of reasons, including loan financing. The date on which possession will be turned over to the buyer must be indicated. The property should be vacant at the time possession is transferred. The seller has responsibility for terminating any existing tenancy and complying with applicable rent control laws. If there are any assignable warranties on any item transferred as part of the sale, the seller will provide copies of the warranties to the buyer. All keys, electronic opening devices, security codes, or other devices will be provided to the buyer at the time of possession. If applicable, the buyer may need to make a deposit for keys to common areas. Contingencies and removal of contingencies. This section includes further explanation of the need to identify any desired loan, appraisal, property inspection, and other contingencies if they are to be part of the purchase agreement. Items included in and excluded from sale. Fixtures are included in the sale of the real estate. A flat panel television attached to a wall of the property by a bracket is not considered a fixture. Any item of personal property that will be included in the sale must be specified. Better practice is to sell such items separately so that their value is not added to the property's value for property tax purposes. Allocation of costs. The buyer may require the seller to provide a pest inspection and report. Allocation of the cost of property inspections as well as other costs associated with the transaction, such as transfer tax, is subject to the negotiation of the parties. In a strong buyer's market, the seller may bear more of these costs. In a strong seller's market, the buyer may offer to pay more of these costs as an inducement to the seller. Local custom and practice also may be followed. Statutory disclosures. All legally mandated disclosures must be made whenever applicable, including federal lead-based paint disclosures. The first 2 pages of the real estate transfer disclosure statement must be completed by a seller of a residence of 1 to 4 units. Property located in a very high fire hazard severity zone must be identified. The Foreign Investment in Real Property Tax Act FIRPTA and California laws must be complied with. All written contracts for sale or lease of residential real property must contain a specified notice regarding the database www.meganslaw.ca.gov maintained by the California Department of Justice, containing information on registered sex offenders. The form also includes a notice regarding the location of gas and hazardous liquid transmission pipelines. Limitations on property located in a condominium or common interest subdivision must be disclosed, including provision for vehicle parking and a copy of the most recent 12 months of minutes of meetings of the Homeowners Association. The seller must disclose known material facts and defects affecting the property and all other disclosures required by law. The seller must disclose any known insurance claims made within the past 5 years or provide the buyer with permission to contact the lender to obtain such information. A seller may make an as-is sale but still must maintain the property, disclose any known material defects, and make other disclosures required by law. Buyer's investigation of property and matters affecting property. The buyer has the right to conduct investigations or tests of the property, including tests for lead-based paint. The seller is not liable for any harm to the buyer and any inspectors or other workers acting on behalf of the buyer. Title and vesting. Title insurance is the norm in California to protect the buyer's ownership interest. Time periods, removal of contingencies, cancellation rights. All parties need to act promptly on all contract requirements, particularly when a property appraisal is being performed, there are condominium or other documents for buyer to review, or there are lease or other agreements that buyer is assuming. Buyer is reminded that there is no contingency for the sale of buyer's existing property unless noted in the agreement. Repairs. Necessary property repairs must be made before closing. Final verification of condition. A final walkthrough inspection of the property by the buyer a day or 2 before closing is always advisable. Prorations of property taxes and other items. Expenses of ownership usually will be prorated so that seller and buyer pay only the amount attributable to their separate periods of ownership. Brokers and agents. A separate written agreement specifies how the broker is to be compensated and by whom. Joint escrow instructions to escrow holder. The terms of this agreement also serve as instructions to the escrow holder. This provision was included so that the escrow officer will not have to duplicate the language from the purchase agreement in the escrow instructions. Selection of service providers. Brokers cannot serve as guarantors of the quality of service of any company or individual that they may be asked to name. Multiple listing service MLS. Use of the MLS is authorized. Attorney fees and costs. In a legal action between buyer and seller, the losing party will pay the other side's legal expenses. Assignment. Seller's written consent is required for the buyer's assignment of all or part of the contract, unless the buyer is assigning an interest to the buyer's own trust or a wholly owned entity of the buyer. Equal housing opportunity. The sale must comply with all applicable fair housing or equal opportunity laws. Definitions and instructions. Important terms are defined. Terms and conditions of offer. The buyer and seller must understand that the offer to purchase is not a binding agreement until it is accepted by the seller. If the buyer defaults after acceptance by the seller, the buyer may be required to compensate his broker. Time of essence. Entire contract changes. This writing supersedes all earlier written or oral agreements. Legally authorized signer. If a legally authorized signer for the buyer is identified, that person is considered to be acting as the representative of the buyer and not in their individual capacity, unless otherwise noted. Liquidated damages. Civil Code Section 1675 sets the amount of liquidated damages, automatic damages, on the buyer's default that is presumed to be valid at 3% of the purchase price. Mediation. Buyer and seller agree to submit any dispute or claim stemming from this contract to mediation before resorting to arbitration or court action. Arbitration of disputes. Arbitration may be agreed on as the next step following an unsuccessful attempt at mediation. Certain legal matters may require specific legal action. Buyer's offer. The offer will be open until the date and time specified. Acceptance. The seller, by signing the contract, claims to be the owner of the property or to be acting with the owner's permission. The agreement serves as a confirmation of the agency relationships. The agreement also serves as an acknowledgement that the escrow holder has received it and agrees to serve as escrow as directed. The natural hazard disclosure statement must be provided in residential transactions of 1 to 4 dwelling units. Exceptions for spouses, co-owners, and others are found in Civil Code 1103.1. Other items may be covered in addenda to the purchase agreement. The possible presence of mold in a property has become an important topic, as has the possible presence of radon gas. While it is not the responsibility of the seller or the seller's agent to test for either mold or radon, if either is known to exist on the property, it must be revealed to a prospective buyer. A number of cities require specific property inspections, fees, or taxes on the sale or transfer of real estate. Local requirements must always be investigated and met. Appraisal notice. California has mandated a new notice requirement for real estate licensees and others involved in home sales and financing. As of July 1st, 2022, every real estate contract for the sale of single-family residential property must include a notice stating that the appraisal of the property must be unbiased, objective, and not influenced by specific factors including race, color, religion, gender, sexual orientation, marital status, medical condition, military or veteran status, national origin, source of income, ancestry, disability, genetic information, or age. The notice must also include information on actions a buyer or seller can take if they believe an appraisal has been affected by any such consideration. The same notice is required when a real estate licensee is involved in the refinancing of residential real estate of up to 4 units. Counteroffer. If the seller changes any of the contract terms, the seller makes a counteroffer. Any change by the seller rejects the buyer's offer as originally written. The seller can change terms only by, in effect, creating a brand new offer that replaces the buyer's original offer. The seller attaches a counteroffer to the original offer, indicating in the counteroffer the changed or additional terms. In the contract for the acceptance paragraph of the purchase contract, indicating that the contract is accepted subject to the attached counteroffer. The total number of pages then will include the counteroffer. A counteroffer form leaves room for the seller to include any change or addition to the buyer's terms that the seller wishes. The form should be dated and the parties named. The seller should place a time limit on the buyer's acceptance of the counteroffer. 1 or 2 days may be sufficient. The seller signs and dates the counteroffer before giving it to the buyer. If the terms are now acceptable to the buyer also signs and dates the counteroffer and a binding contract is created. The buyer could instead counter the counteroffer by making a correction or addition to the terms of the counteroffer and executing a new counteroffer. Other real estate contracts. Option. The right to buy property at some time in the future at an agreed-on price is called an option. Some form of payment consideration is required for an option. The payment is called an option fee. The person who acquires the right to purchase the optionee pays the optioner the property owner for the privilege of holding the option. The option agreement is unique because it provides the right to exercise or not exercise the option, while preventing the property owner from canceling the option during its term. The buyer of the option is, in effect, buying time to make a decision. The option right also may be assignable. An option is frequently combined with a lease in the expectation that the lessee will want to stay in possession of the property at the end of the lease term by exercising the option and purchasing the property. Exchange. In an exchange, owners of different properties transfer title to each other. The exchange may be a tax-deferred transaction if it involves properties held for business or investment purposes. An exchange may be accompanied by additional consideration if one property owner has a higher equity value than the other. The additional consideration, called boot, is taxable to the party receiving it. Who bears the risk? What happens if a house burns down while a sale is pending? Or what happens if a tree is knocked down in a storm and damages part of a building? Does the buyer still have to buy the property? Does the seller have to repair it? California has answered those questions by adopting the Uniform Vendor and Purchaser Risk Act, which is found in the Civil Code. The answers depend on whether the buyer has already taken possession of the property or taken title to it. The law states that every contract for the purchase and sale of real property will be treated as if it included the following provisions. If a material part of the real property is destroyed without fault of the buyer or is taken by eminent domain, and neither the legal title nor possession of the property has been transferred to the buyer. The seller-vendor cannot enforce the contract, and the buyer is entitled to recover any part of the purchase price that has already been paid. If either legal title or possession has been transferred, and all or part of the property is then destroyed or taken by eminent domain without fault of the seller, the buyer must still complete the terms of the contract and is not entitled to recover any part of the purchase price already paid. Exchanges often involve loan assumptions, cash payments, and other forms of financing. Because of this, and also because of the possible tax consequences, handling an exchange can require a high level of expertise on the part of the licensee. An exchange should always be reviewed by the principal's tax preparer.